All righty, we're back. Thanks for staying with us for that
It's very long.
long break. But it's now officially 9 o'clock. We're going to rant a little bit and talk more about the semi-legalized event that just took place here, which involved actually getting onto the ballot the legalization of marijuana, no longer criminalizing it. All right, so I want to discuss something. It's kind of inherent in the things that go on in the day-to-day of the criminal justice system, and is often not discussed. It's oftentimes gauged in the principles of recovery and the resources and assets that the court can offer to the public when they have issues. But I want to call it what it really is, which is a probation, drug testing, industrial complex. And I mean that because if you sit in any court, you'll see that I would say that 40% of the cases are medical marijuana or marijuana cases, 40% of them. We know that the lab testing uses 40% of its budget to test marijuana. Answer the question, why are the rape kits going untested? But beyond that, there's this whole other industry that thrives on the citizens that are involved in the court system by charging fees and for drug testing. And it's really a phenomenon. It goes without really being discussed. And it becomes such a part of the system now that it's not just discussed, it's become the norm. I mean that just starting with the position of bond, right? Someone shows up for bond, they're presumed innocent. And the concerns that the court would have would be, generally speaking, if it's not a murder case or capital case, if they're a threat to the community, if they're out, and if they're going to be a flight risk to leave, or if flight risk to not come back, and if they're dangerous by being out. So the best examples of when a court may act in this regard, even considering that the defendant standing before them, they're setting bond, is presumed innocent, right? It may be something that involves alcohol, where the allegations involve drunk driving, they involve domestic violence with alcohol being involved. And these are the allegations. That's the charge. It's seemingly are part of the allegations. Now, I say that because there are identifiable things within those allegations. There's assaultive behavior, which is a behavior that is not acceptable in our society, and you'll be punished if you use assaultive behavior, battery behavior. And also alcohol, which is not a medicine, but is a recreational, legal substance, which is not a schedule, but should be Schedule 1 and probably illegal. Nevertheless, it's something that they can take away from you being able to use while you are tied to the court system, whether or not your case may involve alcohol. And what I'm saying about this is that I'm not advocating, I'm the last person to advocate pro-alcohol in anything. I think it's a terrible drug. It causes a lot of problems for people, and as I said, it should be illegal. I say that partly joking. But if you look in the court system, when you get brought in a case, they assume you have an alcohol problem. And independent of whether there be any allegations about it, they're going to test you. They're going to tell you can't drink, can't go to establishments that serve alcohol. They're going to test you regularly to make sure you're not drinking. And if it does involve those things, I understand it, and that's something that they may want to monitor while that's taking place. The standard language that brings about this issue is no illegal substances and only things prescribed by your physician can you ingest. Those are the exclusions. So, my usual perspective as a lawyer when I'm standing there doing an arraignment with a client is if they don't specifically preclude or prohibit medical marijuana, I'm not going to bring it up because to me, you can't use any medications that aren't prescribed to you is akin to a doctor's recommendation to use medical marijuana. So, of course, different courts treat it differently. Some courts don't test when you're on bond. Some will say you can't do it, and they won't even test you. You come in the first time, it's the first time they test you, they don't even know, or understand how the levels work or whatever. But each court's a little bit different, but even more so is what happens when someone pleads guilty or is found guilty and how the court treats the sentence. And this brings me to this case that we had last week, which to me just totally exemplifies the rant here, which is about the probation, drug testing, industrial complex. So I have a client who calls me and says she's got a probation violation. And it means that she was on probation. I did not represent her initially, and she had pled guilty to a alcohol-related driving offense. And as it goes, and I say this to people that are looking for representation in this area, you are going to be presumed to be an alcoholic no matter when you get there. And it doesn't matter if it's your first drink, last drink, you're coming home from opening day, a wedding, that's how they're going to treat you. And if and when you are assessed on your alcohol behavior and habits, if you deny these things, you will be deemed as being not honest about your issues with alcohol. And there's tests that are given, they're required by law that be given for certain types of crimes, employing the need and personnel in a probation department, not just be there to assess and give the test, but interview you and write a recommendation. So these are things that are built into the system that all surround trying to assess the person's need. Now, when I say that you're presumed an alcoholic, if you have an alcohol-related, they will learn soon enough whether it's true or not. Because if they put you on some strict, restrictions, and you can't stay away from the sauce or whatever, or you're not benefiting from whatever confines they're putting you in and restrictions or treatment, they're going to know. But if you're able to, then obviously it's not, they'll back off on it. But the courts are always going to rule heavy on when they can't, testing, and it's just a safety for them. I mean, I would say put it off the side whether it's justified or not. The court's decisions are usually that they don't want to get in trouble. They don't want to be the one that lets someone out on bond and they kill someone driving. That's not good for them. They know that. So they err on the side of nevertheless. So as my client comes into the sentencing pleading guilty, she shows up and they're recommending 4 days in jail relative to her alcohol-related offense. And when she shows up, she believed that she would be able to maybe talk the court into maybe waiving it or setting it aside to the end of her sentence, as sometimes courts will do, knowing that it's hanging over her head and it kind of be a motivation for her. The court was intending to sentence her to jail. So she said if she could come back on another day, because she was working 3 jobs at the time, the judge said, okay, I'll let you come back after the 4th of July or what have you, but you're going to get 10 days. So you can either do 4 now or 10 days later. And she had 3 jobs, and she needed to check out with them, and she took the 10 days and got out and reported to the probation department and explained that she was a medical marijuana patient. She never met a probation officer directly. Now, this is in a city that you wouldn't think is really like this, but they are. And they've created their own, quote-unquote, community correction service. The state of Michigan's got the Department of Corrections, which manages the prisoners, but also the probation departments of all felony courts all over the place. The misdemeanor courts have their own way of doing things. Some of them try to mirror the state's process, but they do whatever they want, and it's all local. And especially the district courts, one of the ways that they, control the herd is to rotate them through these testing procedures. And in the area that we were in, which can remain nameless, they have this quote-unquote community correction. Oakland County has got jams. Anyone that's ever been on probation knows about jams. They give you a color and a number, and it's already deemed, which one of these is going to be more
Call
reporting.
the hotline.
Yeah, and you got to call every morning. If your number comes up, you got to go in, and they do it like clockwork. People are lined about the door. Anyways, and this will happen in any case when you come in. It's like automatic, and they're expecting it to happen. Judges are going to do it no matter what. So my client, reports to the probation department, provides her the intake, doesn't meet her probation, and is given traditional terms that she's got to comply. She gets involved with Dawn Farms outpatient alcohol treatment for 12 weeks, graduates, and gets a certificate. She begins AA, and I didn't know that this existed, but there's a secular AA called SMART, which she enjoyed and actually thrived on and has continued to do that, and paid all of her fines, and got her 1 job back and whatnot. But she has a terrible migraine history and uses medical cannabis. And at a point in time, after a year that she's on probation and actually writing in, it was a write-in probation, you have to report. After a year of no issue in accomplishing things that she had accomplished, the probationer called her and said, random drop. You have to go drop. So she went and dropped and tested positive for THC. She said, well, I have a card. She said, well, you're going to have to get us a letter from your doctor that certified you. So they got that, and it was a great letter and, outlined the bona fide relationship from the certified doctor, identified the issues in the medical records. This isn't good enough. We need a doctor. This is not an approved doctor. She then went to her U of M doctor who's been treating her since she's 15 years old. Woman's like in her 40s now. And the U of M doctors, of course, cannot write the certifications, but wrote in this letter, she is antagonistic to all these traditional medications, that are used for the treatment of, and I support her medical use of cannabis. We know she is in her medical records that show that they were acknowledged in their tests or whatever. Not good enough, says the probation officer. Now, this is a little bit of a weird case, and I don't want to give away any of the identifying locations or jurisdictions, but my appearance in front of this judge was this judge's second day back after a 2-year suspension. You can add it up. But what is interesting about this is during this period of time of 2 years, or shortly after he had put her on probation, I think he was given his hiatus. And there wasn't the same probation officer with the oversight of the court like they usually have. If a probation officer wants to violate their probation they've got to bring it to the court's attention. Court will sign an order of violation which compels them to show up to court and answer to that. This judge wasn't around for 2 years. So after the first year there was no issue. After the drop of dirty and the presentation of the medical documentation, it was just a battle between her and the probation officer with no oversight. They're like, this is not a doctor that our department has approved of. So what happens is this goes on for a couple months, and they do a show cause.
Who are the doctors that they approve of?
Exactly. So they issue a show cause for her to show up and explain why she shouldn't be violated and what her excuse is for using marijuana. Now, the original order was, as I told you, that traditional language of no ingestion of any illegal, illicit substances other than those prescribed by your physician, right? And nothing like no medical marijuana. Nothing to that effect. So, and she has a card. And they know she has a card. And as it turns out, the day that this is occurring is precisely 1 month from her 2-year period of probation. And she's now been clean for 2 months because they threatened her. And she stopped using cannabis. She can't even work. Her head is, okay? So I show up and and I start talking to the probation officer, and she starts telling me about, I say, I want to see the original order. It says, there's nothing about medical marijuana. This doctor isn't approved by us. The